Okay, today's we are continuing polity, static. Okay, what had we earlier studied, and in the static series we'll use less of the template slides form and we'll see the normal hota na old school how student, teacher and student used to study. We'll try that. Earlier what had we finished? Remember the code? It was CPPP. This is what has been done in brief. C stands for criminal justice system. There are 3 P's. The first was pendency of cases. Second was prison. See, pendency. Second was prisons. And third was what? Principle of justice. Okay? Of justice. This all has been completed. Now, what we'll do today? What was next after that? Next was what? LPJ. It is usually said LPG, liberalization, privatization, globalization. But for the mnemonic format, we are doing LPJ. That is, today's first topic is legal framework. From many classes, we have been discussing what is the new legal framework. The old IPC, CRPC, Indian Evidence Act, but the new Bhartiya Nyay Sahita. Okay? We'll see that. Second is what? The 3 P's you've done over here. The last P is what? Police. Who deals with the legal framework? Majority, the police and the judiciary. And the third is what? Judiciary. This is the topic for today. The reforms in all these 3 is what in depth we will discuss today. See, a direct question on this is not so much there likely, but these points, like whenever the questions comes of judiciary, you can integrate most of the points. On police, on the law and order system, most of these points can, and even in normal governance answers, you can see directly quote what many committee reports are saying, what the judiciary itself is saying, what is the status of prisons, what is the status of police. All this can be quoted. Okay, now, so we'll start. The first was, again, L, that is the legal framework. Now, what was the earlier legal framework? So, first, to understand the legal framework, you need to understand what? The word law. What does the word law mean? Okay? So, law has basically 2 definitions, multiple definitions, but for today's class, we are taking 2, a very generalist view, okay? And one by some famous lawyer who deals in such things. We'll read these 2. The first is, what is law? A set or a system of rules and regulations enforceable by the social and governmental institutes to regulate the behavior of people. See, it has to be a set of rules, okay, guidelines, regulations, enforceable by both. First, there has to be rules in it, okay, and second, enforceable by both. The society itself, whatever the rules may be, the society also has to accept it. The first part is the society has to accept it, because the society has what? The society has numbers. And second, plus the government or the system or the people in power, both have to accept it. These 2 are, and the main aim is what? To have rules, acceptance, to regulate, to stimulate people's behavior or people's day-to-day lifestyle. That is the most simple definition of what is law. Now, if you want to see what law means on a intellectual level, okay? So there's a person, his name is John Austin. Again, I repeat, his name is John Austin. Law is a command by the sovereign backed by the threat of sanction. Here the novel word is threat. Okay? Law is what? Again, law is a command, that is a set of rules, command by the sovereign. Sovereign means again the state, and to some extent sovereign means the people also. Okay? If you don't know the meaning of sovereign, you have to see the previous classes and understand what is sovereignty. Okay? Backed by the threat of sanction. Here the extra part is what? Threat plus penalty. Okay? Now you understood the basic definition of what is law. Now there has been a lot of change happened in the whole Indian legal framework. Lot of change. It has been to some extent overhauled. Okay? So first you need to understand what was the background. What was earlier that used to happen, then you will be able to understand what has been changed and how it will relate to our future prospects. Okay, now what has been changed? First, we had 3 parts. Okay, everyone has memorized it. First was IPC, okay, 1860. Then was CRPC, and third was Indian Evidence Act. Okay, Indian Evidence Act. Understood? These three form the plinth or the foundation of the criminal justice system or the Indian legal framework, mostly in the context of criminal laws. Okay. Now IPC is 1816. When was CRPC? It was 1973 and 1973 and this is 72. Just remember it. You don't need to remember it, but to just get but now these are outdated laws. So you don't need to remember the specifics, but just for general view. Okay. It was 1872. Now, another important thing which you need to remember is, see, there has been numerous debates on how these laws were to some extent unjustified or not according to the present times. They were not modern enough. They were not equivalent to what the Indian society or the Indian taste, Indian laws, Indian structure. But all these debates were going on. In the meanwhile, we have to always remember the recommendations, the committee reports, whose advice were inculcated through the future generations or the future regulations. The committee report was Ranveer Singh Committee. See, there were many flaws in this, many flaws. They were not flaws, but they were not to the taste of Indian people or the Indian structure as a, because what? The basic flaw which this had was, all these were mostly based on colonial laws, colonial era, colonial times. And what did the colonial times represent? They represented the suppression of the Indian people. They represented the suppression of the whole Indian subcontinent, and they worked in favor of whom? The British, the colonial Raj. Therefore, that was the basic flaw, that the main aim it had was not suited to Indian needs, Indian society. Okay, so all this was there, and then the major committee is Ranveer Singh Committee. Okay, who was Ranveer Singh? Matlab, he had many attributes to his name, many characteristic traits, but majority he was the Vice Chancellor of National Law University, Delhi. Okay, Ranveer Singh Committee, write it down. Ranveer Singh Committee. And when did it submit its recommendation? Was 2020. Okay, this was the basic framework. Now we'll see how these earlier laws worked, not into too much detail, but what were the basic drawbacks. First, why was there need of reform? To understand all this, you also need to understand a very novel term, okay? A doctrine of progressive realization of rights. See, the word is doctrine of progressive. Just write it down with me. Progressive realization of rights. Realization of rights. See, what does this mean is, it is basically related to what? Fundamental rights. Okay? But you have to draw a parallel between what is going on. This basic means is the law or the rights which had been encompassed during or after the commencement of the constitution. 70 years has passed, 50 years has passed, and time has been passing by. So these laws have to become in tandem or have to be upmarket with the present times. That is why it is called progressive realization. People, the courts, the judiciary, everyone progressively realized that this law needs to be changed with time. For example, in the last class what we discussed was right to dignity or the right to reputation. Okay? Article 21, one of the most heated debated articles because its expanse is just ever growing. That is what? Progressive realization of the rights, that these rights need to be expanded more. This is specifically related to fundamentals. In the same case, comes with laws. See, these IPC, CRPC, Indian Evidence are what? They are 70 years old. Not just 70 years old, they are more than 150 years old, because 70 years we have been copied these acts from colonial times. Though when it became in the colonial times, if you add that time period, it is more than 100, 150 years old. So with time, these laws need to be changed. So you have to relate it to what? Doctrine of progressive realization of rights, or doctrine of progressive realization of the present legal system also. Okay, that was just a reference. Now, why were the reforms needed? Okay. Now we'll get into the nuances, the basics, that why reforms are needed. Okay. Just write it down. You have to write it down in point format. Why were the reforms needed? And we'll see priority wise what was the. Okay. First, as we discussed, what? That it was colonial. Okay. There were colonial laws. So you can write it as aim. We discussed again, just related to it. What did we discuss in right to dignity? That Now we have due process of law with procedure established by law. Earlier we had only procedure established by law. Now we have what? This plus due process of law. What does due process of law? Due process of law says that you have to see the intention, the fairness and the reasonableness of the people who are making the law. The intention is also as equal important as the law. Therefore, what was the aim, the intention behind the people who made these laws, the colonial laws? The intention was to suppress the Indian subcontinent, suppress the very idea of freedom, the very idea of nationalization, and support whom? The British Raj or the British colonial era or the Queen itself. That was the main idea. So these were colonial laws. The aim of British was to rule India. Therefore, suppress all kinds of freedom, responsibility, any idea which was opposed to the idea of the colonial Raj was to be suppressed. Now this led to what? The second point is, which we are seeing as of today also. How many crores cases of pending are there? Pending cases are there. 4.4 crore cases. So it leads to the next point, which is what? Pendency of cases. By following these earlier laws, earlier codifications of laws, there were so many pendency of cases. Therefore, we also need to overhaul these laws so that this pendency comes to a stop still. That was the second point. Third is what? It is very law. I'll just write it down. IPC, just for reference. CRPC, and the third is Indian Evidence Act. We are talking everything in terms of these three as of now. This was the first point, the second point, and the third point is what? All these three laws are very technical, not to the common understanding of normal people or even intellectual people who are not sound in the law sense. There might be people who are very much intellectual in science, maths background, but the technical knowledge of law is not in their forte system. So these laws are very technical and very complex. Why? Because it was drafted by the English people. And all these are connected. Very technical because what was the aim? The aim was to, there has to be a divide between the common people and how law is framed. Because if the common people understand how law is framed, how you can utilize law, then they can stand up against it. They can ask for the rights. That is why it was made technical and complex. So that the common law, the common educated individuals also had to have some tough hard work to understand these laws. This was the next point. And again, if you have to always keep an eye, if the laws are technical, they are complex, then that leads to what? Again, it leads to increased pendency of cases. Aim, that is different. Because it was structured in such a manner, it was institutionalized, a better word, in such a manner that all is leading to one another. There is technicality, therefore it is leading to complexity and therefore increase in pendency of cases. Now, what is the next? Next is a very core theme, that was idea of justice. We studied justice was of three forms: reformative, distributive and retributive. So earlier what was the justice form? Idea of justice was earlier retributive, like retributive in one line means an eye for an eye. I've told in all my classes, if you want to remember, retributive is an eye for an eye. Distributive is according to your whatever crime you've committed, the penalty should be according to that. And reformative is what? To reform you, because criminals, it's just a way of saying criminals are part of society, and the whole idea is what? To reform the society as a whole. So earlier was retributive. During the British era, the idea was retributive. And now we are wanting to seek what? Reformative. Because everything is connected. Why did they want retributive and eye for an eye? Because they didn't treat us as their own society. They treated as what? Just raw material department. That is out. Now, this you might all relate to. These were 100 years old laws. So there have been new forms of crime that we are seeing every day, like cyber crime, cyber warfare. So many new things are coming in the form of negative crimes. So all these things, all three acts didn't have any codification for related to that. There was no umbrella law for regarding what? Cyber crimes, digital crimes. There was nothing such. So we need new laws for new crimes, digital crimes. There are many other crimes, but digital crimes we see every day in news. That is why I'm relating to it. Next, there were various loopholes. That is how all the legal framework, the criminal justice system was working, and all the criminals used to. This is a very generic statement that there are various loopholes, because to understand the various loopholes, we have to understand the very act. Like if someone is getting bail for murder, so there might be a loophole in that specific codification of the murder laws. So a general statement is there were various loopholes, and Next was lot of ambiguity and vagueness, ठीक है, because lot of ambiguity and vagueness, ठीक है. This is again what? Law specific. Like, what is the definition of sedition? मतलब all around there's a debate that was the definition of sedition. Why is this so? Because there is always vagueness and there was ambiguity. The law which had been made like 100, 150 years ago did not specifically define this thing. That what is that? Another is what? Disaffection. Disaffection towards the state or personal disaffection. What is the personal meaning? What is the specific meaning of disaffection? ठीक है? It was not clearly stated. Therefore, it leads to what? Ambiguity and vagueness. And this also leads to what? This is also one of the loopholes. See, I told you, this is also one of the loopholes. Okay, now, the other point is, we discussed retribution. From retribution, we are going to reformative justice. ठीक है? But that specifically means what? कि the focus should be now, earlier there was less focus on victim rehabilitation. Earlier we didn't see criminals as a part of society. We saw them as an outcast, but now that idea has to be changed. So earlier there was less rehabilitation. Now less rehabilitation was one of the earlier reasons that we are trying to reform these things. So now we want more rehabilitation. Like if someone has been to jail, just for example, for a minor crime, but he'll have much more psychological impact. And if someone has gone to jail for robbery, just I'm not saying it's a new instance of robbery, just robbery for example, and he's in the same compound with murderers, rapists, dacoits, then see the impact which have. So all that will lead to what? When he comes out, he'll have a huge sociological, psychological impact, and we have to minimize those impacts through rehabilitation. That is the new idea, that we need to rehabilitate. We need to inculcate everyone in the society back again. Okay. Next is new value system has evolved. Because values are also like other things changing with time. Now new value systems has evolved. Therefore, reform acts also need to change with leading times. How the times are changing. Laws also need to change. These are like generic statements you can use in all them. Now see, like we discussed, new value system has evolved. So we need to understand what are values. This is also a what are values. This is what? What are values? This is mostly an ethics question, but for deeper understanding, see, values are of two types. One is the core values. Always remember, core values never change. Okay, core values never change. Second is what? Opposite of core value is what? Dynamic values. This change with time. You have to remember that. Core values never change. What are the core values? Just for example, love, truth. These are the core values. These on them. And what are the dynamic values or what the peripheral values? You can also write / peripheral values. These are values which are in time. They are prevalent with those times. For example, Sati Pratha. At a time it was seen that it is right, but that was with that time. For now it is wrong. It is a grave wrong which is going on. Example, homosexuality for example. That was also not accepted to society. As we discussed, what was law? It has to have the acceptance of society. But for now, homosexuality in specific has been accepted, which was far wrong for a previous period of time. So therefore, these comes under the dynamic law. But always remember, core values never change. Another example of dynamic law is what? Abortion laws. I think you get the idea what is core values and dynamic values. Okay. Now, you have to also see the value system in what? In the sense of political structure. For example, first we used to have what? Autocratic systems, oligarchy. Now what we have? Democratic values. That was also how values of the political structure in. First, autocratic we had, in some places, / we had oligarchy. Now what do we have? Now what is the general opinion? What has the world accepted as of now? What we should aim is what? Democracy. This is also another part. See how value systems are changing. Now, next is what? Next is ethics angle. Because see, we are going to accept the ethics angle also. What it says, ethics says to judge your action based on the society value system. For that you have to understand the value system which we discussed. See, ethics says your actions are based or decided or judged to the present value system of the society. So if the society for that time was saying that homosexuality is wrong, so the society as a whole accepted it is wrong and individuals also accepted. But as of now, with various judgment also, we have accepted it, that it is part and parcel of life. So now according to the present value system, it is accepted. Next comes what? Okay. Therefore, reforms, laws always have to be according to time. It is like new knowledge, new science. With time you have to accept it. Okay. Chalo. Now what that means is, okay, you have to understand the means and ends principle. Okay. All this is a bit too technical, like this is the means part. Okay. And this is what? The end. Now what comes in the middle? The means and ends principle it is called. What it says is, okay, means is a way to achieve end. Okay. Now, how will you achieve? Means is what? A ways to achieve end. The end goal is always the end. Now, how will you achieve it? That is the question. Okay. Achieve how? Laws. In British time, how did you achieve it? Okay. Because end is relevant to aim. So, what was the earlier aim? Economic suppression of the individuals. है ना? What did the aim of British? What was it? To economically suppress us, to financially suppress us, to matlab humiliation is the best word. So during British times, it was economic suppression, it was economic exploitation and suppression of freedom. This is pre-independence. Okay? The time on which the laws were made. Now, if same thing, means and ends principle is over here, what is the present time saying? Now, present time is saying the means is what? End is what? End is reformation, inclusion in society and rehabilitation. So, if your means and ends are changing according to times, that. So, what is the new means? New means is what? Development, inclusion, rehabilitation, all these work. Inclusive growth, welfare. Therefore, means should change according to ends, always. If your ends are changing, like if you are preparing for an exam, simple, whatever exam, UPSC, state PSCs, Harvard, Cambridge, whatever. So, that is your end goal, that is your end. So, whatever exam perspective you have in mind, your means should change according to that. Your books, your present day format, your syllabus, everything, even a specific schedule should change according to that. For example, if you're wanting to become a sports person, your eating habits or sleeping habits also change according to that. Therefore, always, end is more important. So, means should always change according to end. And according to Gandhiji, okay, that's a different thing, but Gandhi said means are always equivalent to the end part. Okay. This was the first thing. Now, what are the reforms in the criminal law which were needed, and that we are seeing these reforms in criminal law. The first reform is again for reformation. Okay. Reforms is you can easily read reformation of two things. First, the individual itself, okay? And second is society. Reformation in both individual and society. Second is victim protection. See, there is a difference between victim and perpetrator. Until you are deemed guilty or until it has been certain that you are the perpetrator, until that time you are the victim. So, victim protection also needs to be. And third is simplification of laws. Okay? Because earlier there were lawyers who basically drafted all these laws, but now we have to make it understandable for the common people, for the common lawyers also, because everyone has to know what they are being judged for. Okay? So, simplification of laws, because simple language will mean less ambiguity, less ambiguity. Second part is what? Again, less vagueness. And all this leads to what? Empowerment. Loopholes will be minimized. Okay. Now, again, we've seen what reforms is. Like in everyday news, what? Gender reforms. Yeah, gender neutrality reforms we need. Okay. Gender neutral laws. Gender neutrality laws. Gender neutral laws we need. These are the reforms. What more do you? If you just think of everyday news, everyday common things, you'll get a grasp of it. Next is new offences we discussed earlier. Why do we need reform? Because there are new offences and we need to cater to those offences. Next, reducing ambiguity, vagueness we discussed. One, witness protection. With victim protection is another, witness protection. And there's a whole, to some extent, there's a clause which you can consider. Whistleblower Protection Act is also there. That is leading to something else, but that very core idea is same. What? We need to have witness protection, because these are the main people who are, or through which justice is being delivered. Witness protection. See, because there is, we'll see in detail, but there is what? Primary evidence and secondary evidence. Witness protection is a part of primary evidence which is given prima facie importance. All the secondary evidence, the oral evidence, these are got given secondary importance as the name suggests, but witness protection is given primary importance in the eyes of the law. Therefore, we need to protect them. What is next? Now, how all these, another important reform is institutional reform also. If you will see, institutional reform. How will you write institutional reform? See, next point is institutional reform. See, this is again a very framework reform. Okay, very generic statement, but how the whole machinery, how the police, how the judiciary, how the law works also has to work in them. That is what, in this you have to understand what? The laws are being implemented, the judiciary, pendency of cases, all will come within the institutional framework reform. And what does it? It says about integrated approach. Of all the many things, one is most is integrated approach. That says what? See, you have to draw a triangle, simple. And one is what? Judiciary or the judges system. Second is the police. And third is what? Prosecutors / lawyers. This is the whole integrated approach. All three when work together, justice is delivered. Okay? Keeping in mind all the other reforms which we are talking about. Okay. Now, next is what? We will see just one example or two examples, like according to IPC 499, section 499, just write it down if you want to. IPC section 499 and 500. Defamation is what? See, first to understand definition, defamation, where has been definition said? Article 19. Okay? There are 8 grounds on which freedom of speech and expression can be curtailed. Okay? Remember that. This is a fun fact. And it's a prelims auto. Article 19, again I am saying it, Article 19 has 8 grounds on which freedom of speech and expression can be curtailed. From that, 7 grounds are related to the state or the government / government. It is only one ground which is the 8th ground. That says private people. Now what does this say? Private people says defamation. If an individual, a private entity is defaming you, then also you can approach the courts. And this private plus public defamation can also be done by the state authorities. Now you see IPC section 499 and 500 in relation to defamation. Now we discussed the basic framework of defamation. Now what does article say? Defamation is now a criminal law. Okay? Because in most of the developing countries, okay? Developed countries, it is what? A civil law. Okay? But in India, it is a criminal law. Now, so you understand the vagueness, the complexity. Like most of the developed countries have defamation. When someone is trying to defame you, derogate you, it is a civil law. But in India, it is both a civil law and a criminal law. Okay. So, there is a vast idea of difference. That is there. This is one other. Another example is what? Sedition. There is no definition of sedition in. There is a definition, but it's very vague, it's very vast, and if the lawyers or the government itself wants it, every single thing can be encompassed in the idea of sedition. Okay, that is it. Now, see, sedition law has been changed in the new Bhartiya Nyay Sahita, but you need to first remember what is section 124A. Okay, here definition of sedition is there. We will see in the later slides that it's the same thing, but the very word, the very technicality of the word sedition has been removed and it has been replaced with what? Deshdroh. Okay? But first see what is sedition. Okay? See, I am saying it very slow this time, so just write it down. Whoever, that is the very definition now. Okay? Now definition, whoever. Okay? Definition, just write it down. Whoever by words either spoken or written, or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with life imprisonment. Oof, such a big definition. Now you understood. I'll repeat it once again. Now you saw like so many words are being used and every word has what? Such vast meaning. So everything almost is encompassed. If the state, if the government wants that, if he or she wants to just put you behind bars using the sedition law, they can do. Now just hear it once again. Whoever, this is the definition, section 124A, okay? Whoever by words, either spoken or written, or by sign itself, just imagine sign language has also been included, by sign or by visible representation or otherwise brings or attempts to bring, like if you are doing an attempting also, attempts to bring into hatred or contempt. Contempt word is also there, hatred or contempt, or excites again, or attempts to excite, if you are exciting also, or attempting to excite disaffection towards the government established by law. Again we saw the definition of law. Government established by law in India shall be punished with life imprisonment. Understood? Now see, this whole definition is what? In conflict with section 19 of defamation. Okay? Now, most of the time this act has been misused. We'll see how. Just one example is the very famous example of how this was Bal Gangadhar Tilak ji. Okay? So, the very idea of this is misused because most of the developed countries usually don't have such a law, but we have. Okay? Now, how is it misused? Bal Gangadhar Tilak in 1900s, before independence, 1916 or so, what? Or prior to that also, was sent to jail using what? This act. That is why this act is roughly 150 years old. Now, ambiguity, example, what is disaffection? You're saying what is disaffection? You're saying what is disaffection? Or what is idea to not just doing it, just you're trying to do it. What is sign language? You can't say, like, you can do anything and the person in front of you or the authority in front of you can interpret it in n number of different ways, or just interpret it in the way he or she wants them to, or just interpret them according to the narrative or according to the situation. That is the vagueness, that is the ambiguity of this thing. Now, again, it was used like from pre-independence times to some extent now also, way to gag press or way to suppress the press. Okay? Freedom of press was also reduced by just using the sedition law. है ना? Why? What is the, if you are suppressing the press, okay, or if you are suppressing the individuals, or if you are suppressing what? Freedom fighters. If you just forget the time span and just think from that time, what is the basic idea? The basic idea is to suppress freedom or to suppress the very idea of freedom. Okay? And this law has been used like weekly, monthly. That is the speed at which it is going. Okay? If you are suppressing freedom, what are you doing? You are killing dissent. Okay? See, everything is related. The very idea, the main, why is everything at work and why is everything working in tandem against freedom is because the very idea of the British was to suppress the very Indian individuals. The very idea was to suppress nationalist thought. That is why everything is working so much in synchrony to suppress freedom, because that was the very idea for which it was brought. Next is what? In nowadays you can see it is mostly used to stop the criticism of government and public at large. If someone is trying to criticize the government, be it a good question, be it a bad question, we are not going to the details, but the very idea is to suppress any thought which is against the government. That is the idea. Now comes what? If you are suppressing the very idea that is against government, you are trying to kill political voice also. Okay? In now a few judgments. Okay? I am hoping you are writing everything down. Okay? The next is, in Kedarnath versus state of Bihar, okay, the constitutional validity was upheld of, in Kedarnath, okay, just write it down, Kedarnath versus state of Apna Bihar, constitutional validity was upheld. Constitutional validity upheld. Okay, of what? Of the sedition law, section 124A. It was upheld, but they made a remark, and the remark was what? Okay. until your words, that is whatever words you are saying or message or to some extent sign, ठीक है, whatever sign you are doing, ठीक है, until your words, message or sign is causing violence, is causing direct violence, होता है ना, there has to be a relation with direct violence, then only, until then this section will not be used or cannot be used. मतलब whatever you are saying, whatever you are trying to say, whatever you are implicating through words, sign language, ishara, whatever, if that is directly correlating to violence, effectively, immediately, then only this clause can be used, otherwise it won't be used. That was. Now, there are so many sedition cases being lodged in the police courtrooms or even the judiciary, but how many of them are actually convicted? That shows the percentage of which that actually represent that whether they are actually using the sedition law. The percentage is what? Only 3% conviction rate. Matlab 97% of the cases don't fall under the ambit of sedition. That is the court's rulings. Okay, now what has the SC said about it? That is also important, because whatever the Supreme Court says, it's law, like they are the final interpreters, they are the final guardians of the law. So therefore what they are saying is important. So what the Supreme Court has said is what? It should be reframed, the very word, the very definition should be clarified, and any criticism, any criticism, sloganing or just saying anything about the government is not sedition. In matlab criticism of the government is not equal to sedition. Just write in short, criticism of the government is not equal to sedition. But where was it said? It was said in Balwant Singh versus State of Punjab. You need to write that, because you have to authentic, make your answer more authentic. Balwant Singh versus State of Punjab. Of Punjab hoye, hai na? Any criticism of the government does not directly correlate to sedition. What else? Bail provision should also, because see in this case now a very difficult thing for the common people is getting bail. So what the Supreme Court again suggested was, if you are accusing someone of sedition, but there should be easier bail conditions, because the conviction rate is so less. So the judiciary, the courts, the general public also knows, in fact the government also knows that we know why they are using it. We know the outcome. Therefore we are suggesting, or the courts are suggesting, that make the bail provisions a bit lenient. That was it. Now this was the criticism. Now you also have to see why. You have to see both sides of the everything is a double-edged sword. A coin, everything is a double-edged sword. So we saw the criticism. Now we also see why people or the judiciary, because judiciary also said now, if there is no direct violence, but then you cannot use it. But if there is direct violence, you can use it. So why are people in favor of it? Why are the lawyers in favor of it, or why the government is also favoring it? First, the most important thing is national security and integrity. Just write it in capital. National security. See, even if only 3% of the people are convicted, but 3% is also a great magnitude when it comes to the question of national security. If national security is into question, then nothing else matters. Okay. Second is what? Masked insurgency. You have to also curb masked insurgency. Both related to national security. Third is separatist tendencies also. See, anyone here and there can't just stand up and say, I need a different state. So this separatist tendencies also needs to be curbed. All the national security, masked insurgency and separatist tendencies need to be curbed. Therefore, this law, according to these provisions, is also very important. Last in favor is Article 19 is not unlimited. Because in Article 19 also there are limitations. Limitation is what? National security, national integrity. On those clauses, freedom can be curbed. That is what we are trying to say. Article 90 is not unlimited. There is also what? Government can curb Article 90, freedom of speech and expression on the grounds of national security and integrity. Now, what's the conclusion? The conclusion is simple, and the government has also concluded to some extent that conclusion is reformation of the laws, reframing of the laws, or overhauling, like changing from the ground up, not just brushing away, changing from the ground up, building a new structure from the new plinth itself. Okay, that is the idea. Now conclusion, reframing. We have evolved as a democracy. Okay. Earlier it was a colonial law, it was a colonial era, but now we have evolved as a, so therefore it needs to change. Therefore, it must be ruled into according to the present 21st century, according to the, to some extent adding to the economic angle, it should be keeping in view of what? The fourth largest economy, soon to be the third largest economy. We have to change our laws according to what? Now we are the fourth largest economy, soon to become the third largest economy. So we can't stick strong with those colonial times, those colonial eras, the colonial laws also. That is it. Now, there has to be, see, this conclusion part is clear definition of sedition. In the new laws also it hasn't been done. The word sedition has been removed. We'll see in detail. The new word is what? Desthrow. But it is still there. So, don't write it as a conclusion, because this is a, the government didn't listen to this part of the conclusion to some extent. Okay. Again, next part of, I told you, what is conclusion? Whatever reforms we are suggesting, if those happens, that is the conclusion. That is what you are trying to say in the conclusion part. Next is what? The conclusion, just mere criticism of the government should not be treated as sedition. That is another part of the conclusion. Now, usage of sedition should only be done in rarest of the rare cases, where violence is directly connected to it. We saw now, that is it. Usage in only rarest of the rare cases, when threat of national security, national integrity, separatist tendencies or Maoist, only in those cases it should be, and those cases are rarest of the rare cases. Okay. Now, last data we'll see. In 2016 to 2019, there was an increase in number of cases. Okay. Up 160%. That is whose data? See, National Crime Records Bureau. Okay. From the last 3 to 4 classes of polity static part, we've seen usually data of 2 to 3 parts. National Crime Records Bureau, Judiciary data, then committee reports. This is all authentic data which I say. National Judicial Commission reports. Okay. So according to NCRB, from 2016 to 2019, how much jump has there been in sedition cases? The jump is 160% increase, 160%. Imagine this number, 160% jump in just cases related to sedition. Now, who has said this? NCRB. So, write this in your introduction also or in your conclusion also, saying the grave matter of affairs which is going on. Okay. Now see, the last concluding line should be what? As we've discussed what were the problems, okay, we've actually discussed what were the problems. Now we'll see the future, which has already been passed and we are now as of using those laws. But the concluding line should be what? Okay. The laws, see, this is said by whom? I am exactly saying, our present Home Minister, Honorable Home Minister, has said this. Amit Shah ji has said this what? He has said that the laws should reflect the spirit of Constitution. The spirit of Constitution reflects what? In simple preamble. What is the spirit? Freedom, integrity. That is what the laws should reflect. And therefore, we need to overhaul all the laws. Okay. Again, there has been more than 7 decades to some extent. In actuality, if you see, it has been more than 100 to 150 years old. These laws are that old, okay, have passed. So, colonial lines, colonial times, colonial areas should be just forgotten. All the reflection, all the past shadowing of these laws should be just forgotten and done away with. Therefore, our Home Minister said what? The laws should reflect the spirit of Constitution. Now we will see the change which has happened. Okay, now the whole change which has been done. The change happened on the date of 1st of July 2024. This was the date in which the old laws had been forgotten. Okay, and the new laws, the new criminal laws came into place. Now, we will see in detail. See, we can't, this is a exam oriented lecture, so we can't exactly discuss all the things which are changed, but the things which are in news, okay, relating to UPSC state exams, those things, what changes were made in those particular acts, sedition law, those we will see in context. So there are roughly 12, 13 that we'll see, but if you try to see everything, then it's not an actual judicial class or lawyers class. Okay, just remind yourself. So we discussed 1st July. On this date, the new laws are there. Now we need to see first the names of the laws. Okay, first is Bhartiya Nyay Sanhita. Okay, you want to write, see, Bhartiya is common. Bhartiya Nyay Sanhita. This is in relation to IPC. Done. The second is a bit longer and a bit complex also. Second is Bhartiya Nagrik Suraksha Sanhita. ठीक है, G is not over here. ठीक है, again Bhartiya. Next is Nagrik, people. Nagrik Suraksha. And again Sanhita, that is CRPC. It relates to CRPC. And the third is what? This is one, this two, and the third, what relates to the Indian Evidence Act? What relates to the earlier Indian Evidence Act? That is Bhartiya Sakshay Adhiniyam. Bhartiya is the word again. Sakshay Adhiniyam. This is it. This relates to Indian Evidence Act. Now see, again just a gentle reminder, on whose recommendations this is being done. See, the government has its very idea of changing things, but they set up a committee report, an expert report. Expert people sit in the committee and give expert judgments also, which if the government wants, they try to implement it. It's not binding, but on whose report? Ranveer Singh committee report. Again, I'm Ranveer Singh committee report. Okay? He was what? Vice Chancellor of Delhi Law College. Again, Ranveer Singh committee report. I'll write it over here. Ranveer Singh. Okay? Committee report. And majority of the changes were suggested by him. It was his recommendations were given what in 2020, and it took. It's not even a too long time. In 2024, these were implemented. Okay. Now, again, Bhartiya Nyay Sanhita relates to IPC. Second is Bhartiya Nagrik Suraksha Sanhita relates to CRPC, Criminal Procedure Code, and the third is Bhartiya Sakshay Adhiniyam, that is Indian Evidence Act, relates to it. But now all these are forgotten, done and dusted. But this is the new law of the land. Okay. Now see, what are the changes which has been done? Okay. First, from where shall we start? Okay, we'll start from the idea of as a society, how the society is being reformed. So earlier there was section 377. So this has been removed. This section dealt with criminalization or penalty of being a homosexual or related to homosexuality. So this has been now done away with. See, we'll do the numbering also. This has been done away with. So what it says was, removed section 377, of IPC. What it did was, it criminalized earlier when it was valid, it criminalized homosexuality. Now it's not there. Second, adultery clause have also been deleted and diluted. Provisions relating to adultery also have been deleted and diluted. Third is, see, you're getting the pattern, right? Adultery also deleted. Now see, section 377 is also homosexuality, then adultery. What does this mean? This means is what? Focus is on gender neutrality laws. Gender neutrality laws. See, these laws were of general people's view, not so much related, but of general people. Now we'll see specific laws. First, done. Now fourth point is, most of I've seen Hollywood movies, English movies, and in there usually the courts give a judgment of what, like for minor crimes, petty thefts, petty crimes. What does the court do? Court gives what? Community service. Community. This idea was not there in India as of before that date of 1st July 2004. So now, for petty thefts, petty crime, community service can be awarded. Now what is community service? See, you all know, and better explanations, just watch any movie, you'll understand. But community service means, the penalty is what? When you serve the community, do some janta work, try and clean the roads, of that sort, teach, go to the villages, teach some poor people. That is part of community service. In usually Hollywood movies, community service also becomes a part of judiciary. When you see the whole court judgment and you have to make an opinion out of it. So that is not as of India, but community service is done. And the clause for community service is what? Whatever crime has value worth less than 5,000 can be given community service. Be ready now to work for the community as, earlier you might have never done it, but now the law will impose that on you. Second is what? Not second, fifth is now organized crimes. It has been defined and it has been codified. See, I'm just writing the words and you have to write down. Organized crimes. Organized crimes are what? Earlier there was no provision for organized crime, but now organized crimes have been added. What does it mean? Simple. Cybercrime. drugs, trafficking, vehicle theft, extortion, land grabbing, contract, matlab the list goes on and on and on. You understand? Now it is there. See, it can be done two ways. It can be done individually also, and it can be done with multiple stakeholders, multiple or gang work. The more nomenclature is what gang work also. So all this has been includes, and the list never ends. Again, I'm saying what it includes. It is not an complete list. Just cybercrime is there, drug trafficking is there, vehicle theft is there, extortion, land grabbing, contract killing. Just use your imagination. It will go that far. Okay. Now there was no umbrella law for the whole of India, but there was specific laws or state-based laws also. Earlier we used to have UAP also related to it, Unlawful Activities Prevention Act. Okay. This was that. Another was Maharashtra had a specific law for Maharashtra. It had MCOCA. For Maharashtra it has MCOCA. See, while the new laws Bhartiya Nyay Sahita also came, so these must also have been reviewed thorough, so to bring a law for all India. So what does it represent? Maharashtra Control of Organized Crime Act 1999. Maharashtra Control of Organized Crime Act 1999. See, now this has been on all India scale. Organized crime has been there. Now what's next? Okay. After organized crimes is the most important, hota na, the terror of terrorism. So terrorism has been defined. The 6th point was terrorism has been defined now, and it has been given a very vast definition that if you just even think of it now, then we'll destroy you. The state is ready to destroy you. Now what does this say? In simple it says what? Just write it down. When any individual, organization, entity, whosoever, threatens unity. First is threatens unity, integrity, security. Again, whosoever, any individual, entity, organization, even a foreign body, anyone who threatens the unity, integrity, sovereignty, security. Last, again, it also adds economic security. Economic security. If you threaten any of this, sovereignty and what emphasis economic security also, then it will be defined or terms as terrorism. Okay. Now another term which was most often in the news but more often neglected because it was not defined or not articulate was mob lynching. Now this has also been codified. What is the definition of mob lynching? Mob lynching is a group of 5 persons or more. Just remember that 5 persons or more, and there are most of 5 persons, and there has been grounds on which it can be done, which have to be restricted. What are those grounds? Grounds of race, caste, community, sex, place of birth, language, personal belief also, personal belief or any other similar ground. See, most of the mob lynching is done on the basis of what? Personal beliefs. So that is also been included, and personal beliefs, and it is also said on similar other grounds also. So a vast, the canvas has been left open also to add new ideas, new thoughts leading to mob lynching. Next, this is a, see, what earlier used to happen was that, first idea, sexual intention with the intention of deceit. If you are making false promises to any individual, it goes both ways. It's not gender specific, it's gender neutral. If you are having giving sexual intentions towards someone and through a deceitful manner, like if you are promising them something wrong, that I'll marry you 2 years later, or I'll give you a job opportunity, or I'll give you promotion in job, and using this false pretext, if you are engaging in sexual intercourse, be it consensual also, but the very intention is wrong, then there is provision for this also. The provision is sexual intention with intention of deceit. The provision is 10 years of imprisonment. Because these cases are coming up very few these days, so we are moving towards a very modernized society, and these cases are coming up. So there was a need to protect it also. Next, sedition law, the famous sedition law which we have been talking for a long time. Sedition law. In this you need to remember the earlier definition, but what has been done is section 20, the word sedition has been removed. Word sedition has been, and the new word is deshdroh. Just write it down. Deshdroh. So all the same things are there, all the same words, terminologies are applicable, but in the new form which is known as deshdroh. If you want, I can just repeat what the definition of sedition once again. Whosoever by word, either spoken or written, or by sign or visible interpretation, again I am repeating, by sign or visible interpretation, or otherwise, the canvas is again open, or otherwise, or excites or attempts to excite disaffection towards the government established by law in India should be punished with life imprisonment. So all these words, terminologies are still there, but just the word sedition has been removed and the new word has been added is Deshdroh. Okay, that is the idea. But okay, now next is, now we've discussed so much about what? Prisons, under trials. Another important is, we'll talk about under trials in two parts. Okay. First, now according to the new law, trials in absentia has been introduced. Trials in absentia. It simply means that earlier it was not there in India, but it is there in many developed countries. It simply means that the person does not specifically has to be present over there. Without his presence also trial can be conducted, because this will lead to what? There are so many under trials. 67% we did were under trial, so the number will reduce. If you're there, if you're present, due to any reason, if you're not present, still the court will do its duties and give its judgment. So this is called what? Trial in absentia. And second, this is the major overhaul, okay, of under trials. Earlier what happened was, what does an under trial mean? Okay, now first you have to understand what does an under trial mean. Any person, accused person, any person accused, held in judicial custody, okay, awaiting investigation. Now the investigation is still in the preliminary stage. The investigation has not been completed. Okay. Inquiry or trial, any of this has not been completed, be it in any stage, but it has not been completed. Okay. But who is also not convicted? In India we say na, you are victim until proven guilty. So this is what it means, that whoever so has not been convicted. Again, under trials are what? Accused persons held in judicial custody. Judicial custody is symbol jail, okay, awaiting investigation, inquiry, whatever you might let's say, but who has not been convicted as of now. So those are called under trial. Now the earlier law, what it said was that if you had completed half of the maximum imprisonment, like if you are gone in there for theft, we'll take petty crimes, theft, and the maximum time was 10 years, for example. Okay. It's not there, it's not factually correct, but for example, you were convicted of theft, convicted is the word, okay, and not convicted, you have been arrested for a crime of theft, you're not convicted as of now. That is why you're under trial. And before seeing the light of the day of trial itself, of the whole machinery finishing its work, you have already completed 50% of your time. If you have committed theft and the maximum imprisonment would have been 10 years, and you've completed 50%, that is what, if you completed a rough calculation 5 years, then bail should be granted to you on the perception of personal bond. Okay? Bail will be granted to you easily with personal bond given. Okay? Personal bond is you have to vouch for it. Okay? That is the idea. Now, what has changed in Bhartiya Nyay Sanhita? The second phrase was Bhartiya Nyay Suraksha Sanhita. That is the modern CRPC. What has changed? Changes. It is applicable for, remember, first time offenders. Okay? It is applicable for, again, first time offenders only. First time offenders. And its simple means is if you have completed 1/3 of the time. Earlier it was 50% of the time. Now it is if you have completed 1/3 of the time, then again you can get bail with personal bond. You have to vouch for yourself. Then again remember, just first time offenders, and you have to complete 1/3 of the time. Okay? Now another important thing is, for whom does it not apply? Okay? Whom does it not apply? It does not apply to serious criminal offences. Okay, and multiple offences. If an individual has been treating, there has been numerous cases against him, so he's not a first time offender, and if multiple cases are there, then also this won't apply. And second is for serious criminal offences like which are punishable by death or which are punishable in life imprisonment, those things don't come under him. All this will lead to decrease in under trials, which is a very good thing. This is a progressive step, remember that. Now comes the serious offences. Next is forensic. Now what changes has been made? Now it has been made mandatory. Okay? Mandatory forensic investigation for offences punishable with at least 7 years or more. So forensic has been made mandatory. See, this is a good thing, because forensic means the details. Devil lies in the details. If everything will be forensically evaluated, there will be chances of both your conviction also or not proving your conviction also. But details are always in the devil. So this has been mandatory for what? Any crime whose minimum is what? 7 years of imprisonment. Okay? Second, what are we all fighting for? Time. We are all fighting for time. Though the timeline has been decreased. See, this is the word, utopian concept, utopian change. I don't see how this will work, but it has been introduced. The timelines have been specifically introduced. See, for example, in cases of rape, there has been given what? Strict guidelines that, you understand, in these cases, the work of medical professional, medical practitioner becomes very crucial. So, it has been mandated that medical practitioners should submit the report within 7 days in cases related to rape. Second is what? The broad context, you remember, the idea behind it is what? I told you, the main thing is that idea is justice delayed is justice denied. So, what are we trying? We are trying to stop the delays. Therefore, justice which is given also should be accepted. So, second, framing of charges by sessions court. It should be done within 16 days. See, sessions court, 60 days. Framing of charges should be done by the sessions court in 60 days. Okay, from the first hearing. Understood? And second, judgment should be given within 30 days of completion of argument. See, when both the parties come in front of the judge, both argue. On the day, the judge says, okay, the arguments are over. From that day, within the next 30 days, judgment should be given. 30 days from last hearing, judgment should be given. Now see, in some cases it can be extendable up to 60 days also, but you understand that this is a very impossible task, but I am happy, we all should be happy that it has been somewhat given. In the law books itself, it has been articulated that this should be done. So someone somewhere will follow this. We are happy with it. Now, next is what? A hierarchy of courts has been established. Hierarchy, see, this is a very small thing. Earlier we used to have what? Metropolitan courts or metropolitan magistrates. In simple, any metropolitan city which used to have a population of 1 million, that is 10 lakhs or more, the state governments had the power to have a magistrate that was called metropolitan magistrate or metropolitan courts within the ambit of power of the state government itself. Now it has been said that metropolitan magistrates are no more there. This clause has been deleted, done and dusted. Now there is only what? And the lowest level is the magistrate court, then comes the session court, then comes the high court, and then comes the supreme court. The role of metropolitan magistrate or metropolitan court, which the state governments had the power to bring up, is no more there. Okay. Now, next, provision of fake news has also been included. Now, provision of fake news. See, these are what? New forms of criminal things, right? Earlier it was not there. Now, what is provision? Criminalization or publishing false and misleading. That is as in criminalization, misleading, publishing false information comes in the ambit of fake news. So this has also been given over there. Next is again related to forensics. Mandatory. See, videography has become. See, a direct question related to all of this is not there, but you can use this in multiple questions somewhere or the other. You can fit these technical points like how our criminal justice system is changing, or what were the drawbacks and what the present text, how we are trying to change them. So, videography of crimes is mandatory. Whatever the police come they draw a barricade, they put up those yellow sellotapes and they do search and seizures. So whatever they are doing, it should be videographed properly. These things are already done in Western developed countries. See, to some extent we won't call them liberal given the present context, but these things are there in the Germany, USA, all these things. So we are trying to some extent learn from them. So whatever the police is doing, searching, seizure, all those should be documented. So it happens, it's good for you that whatever is done is being documented. There cannot be false accusations, false claims. Next is, as I told you again, the idea of secondary evidence. Secondary evidence is now also being given importance. We had discussed what? Protection of witness. That was primary evidence. Now what comes under secondary evidence? Secondary evidence is again oral evidence. What is secondary evidence? Oral evidence, written evidence, electronic evidence. These comes under, earlier these secondary evidence was not given so much importance. Earlier the major things was given was whatever the police, that whatever research work they did, primary witnesses, those were taken into grant. But now secondary evidence is also being given the due weightage. What comes there? It will be given the same status as traditional documents were given earlier. All this is sounding very good. Another important thing is zero FIR. See, if whenever you have been trying to file an FIR, you might have faced n number of problems. If not a simple problem, though, had been there, the problem of jurisdiction. That this, whatever your problem may be, that the individual in front of you, the policeman, might have said this does not come under our territorial jurisdiction, or simply this does not come under our police station jurisdiction. So now the idea of zero FIR has there. What does zero FIR say? Zero FIR says that any place, okay, FIR can be lodged at any place irrespective of the location or territorial jurisdiction. After that, within a span of 15 days, you've lodged a FIR. It is the responsibility of the policeman or the police station itself to transfer the case within or outside his jurisdiction where the appropriate jurisdiction is there. Where it is appropriate to, it is within 15 days that police station officer or whoever the individual may be, he has to transfer that case to the right appropriate territorial jurisdiction. Okay. Now, next is, we've seen all this is the good things. Now, what are the concerns, challenges? Always there has to be concerns and challenges. We discussed them earlier also, but concerns and challenges related to the new, all the three, Bhartiya Nyay Sanhita, okay. Rest is what? Bhartiya Nagrik Suraksha Sanhita and Bhartiya Sakshay Adhiniyam. What are the challenges and concerns relating to them? Challenges / concerns relating to them. First and foremost challenge is what? The power of police has been increased. Okay. Now you see the irony over here. Okay. Earlier, whenever whatever happened, there are two things. One is, you need to remember, police custody. Okay. It is custody. It was there for 15 days max. 15 days max. And after that, the police had to transfer you to what? Judicial custody. Okay. Judicial custody. Custody just after 15 days. Now this 15 days has been increased to 60 days. A 400% increase in jump. 400% increase in jump. Now, any individual who has been accused has to stay with the police for 60 days. Now, just let your imagination flow. All the web series or all the movies you've seen, you can see the negative consequences which it can have. Okay? For example, if you take a more knowledgeable point of view, then with all the technology, with all the present technology, the immense technology, we are giving police more time. It should have been the opposite. That police should have been given less time, because now, earlier it was difficult, but now there's plethora of technology. It's like the Pandora box has already been opened 20 years back. So, but everything should have been eased. But police has been giving more time, like not 1 or 2 days, 400% time or multiple times more. So just let your imagination flow. It's not a very good topic of discussion, that the powers which police has and what it can do. Torture, so many things are there. This is what that. Earlier, as I told you, it was only 15 days, and after that, judicial custody. You need to remember these two names also. What is police custody and what is judicial custody also. Okay, now, and another thing just you have to learn to relate is, like, see, earlier one had to be over here 15 days. Now the time limit is 16 days. This will again increase what? All this will lead to increase in both pendency of cases and overcrowding of prisons. Dono hoga na. If an individual had to leave this place 15 days, now it can stay more. So pendency is also there. Plus overcrowding is also there. Both increase in pendency will also happen and overcrowding. Both will happen. Okay? On both this will lead to what? Again, pendency of cases also. Okay? See, next is, we had said so much that like there will be videography, so many things will happen. But the question is, where is the infrastructure? Infrastructure issues, or in simple, where is it? Both technical infrastructure and physical infrastructure. Okay? Where is the technical, I mean to say digital infrastructure? Like we said that police need to verify everything, there should be videography for everything. So where is the whole equipment, the whole video cameras, the whole hard disk, where is it? Plus digital infrastructure plus physical infrastructure. Like if you are keeping people for more days, you need to have a bigger compound, you need to have more number of jails. If the present thing is going on, if the numbers don't increase, if the number of people being accused are still the same, but the duration has been increased, so where will they go? That is the problem of infrastructure. Okay? More space in jails. Okay? Again, there is no uniform sentencing policy. Okay? See, this is a complex topic. No uniform sentencing policy. There is no uniform sentencing policy. Like if for similar crimes you should have similar penalty also. But we miss this thing according to experts. Okay, just treat it as, if you want to relate it, like think of it as uniform civil code. Okay, we had the chance to make a uniform civil code in the context of criminal laws. In the context of criminal laws. Okay, just if you can relate it. So there is no uniform sentencing policy also, but we had the chance to make it. So it has been seen as what? It is seen as a missed opportunity. Okay, could have more. This thing, if implemented, could have made the criminal justice system more equitable, more consistent. That is the idea. Now, you have to see the larger picture also, irrespective of that. What is the larger picture showing you? The larger picture has 2 or 3 things. First, what's the most in news whenever the justice comes up? Bulldozer justice. There is no mention of, or there is no codification of bulldozer justice. Bulldozer justice. Okay. There should have been a clause that if things go this far, this can be implemented, or exactly opposite to it, that this will never be implemented. Both could have been, but we missed that opportunity also. Okay. Most important larger picture is, when was these laws passed? Now, see, this is according to newspaper articles. Okay. That when these laws were passed, more than, or just remember, 140 parliamentarians were suspended. Okay. 140 opposition members were suspended when this debate discussion was going on. So, if 140 of them are of the opposition members, who, see, the present ruling party doesn't debate with itself, right? If it used to debate, it used to debate in parliamentary committees or private rooms or parliamentary forums. But on the floor of the house, who debates? Who questions the ruling party? It is the opposition. And 140, we all know the status of opposition these days. But given the status also, if 140 of the members were suspended, then who debated, who took part in the discussion? That is the part of the larger picture. Okay, now see. Now the other criticism challenge was like, okay, we all know the present situation of the opposition. But what about public debates? What about public people participating in? What about the intellectual, the lawyers? Where was their debate? When did we take inputs from them? Did the parliamentarians or the regime ruling power, did they take input from them? Lack of political consultation was there. Lack of consultation with the legal fraternity itself. Okay, this was lack of consultation with the legal fraternity was also called into question. Now, but now we'll see, the challenge part is over. But the last point, how it was to some extent countered. Okay, that our present Home Minister, Amit Shah ji, he himself said that large scale public consultations had been done, and large scale consultation with the legal fraternity, the judges, specific state governments. He himself showed that many states had also responded to it, and he gave a long list of data. So that was the countering part of it. Now, what is the conclusion? See, we have to always write conclusion in a positive format. Okay. Conclusion. Now, we'll start conclusion always with the quote. Okay. It's a good thing. Not much important, but if you start your introduction and your conclusion with the quote, it matters that you are a well-read person. The conclusion is by former Chief Justice of India, D.Y. Chandrachud sir. He says, the laws reflect a watershed moment in a country or society. The important word is watershed. Okay, you all know the importance of this word. It is again said by Justice, the former Chief Justice of India himself, D.Y. Chandrachud sir himself, that these laws reflect a watershed moment in the country. So you can quote that. And another thing he said was that the criminal laws reflect the moral arc of a society, the moral arc of a nation. All this in relation to the new laws, okay? New criminal laws which have been brought up. So the criminal laws reflect the moral arc of a society and the moral arc of a nation. Okay? Just remember these 2 words and frame it. Rest is what? Again, rest you will write that we need to follow all those things in letter and spirit, whatever. Now see, what question arises? Okay? There has been 4.4 crores cases still pending. What about these cases? There are so many cases still pending, and the whole legal structure has changed. All the laws have changed. What about these cases? In simple was, old laws will still prevail over these cases. Whichever cases had been written down or brought to notice before 1st of July 2024, those cases will still be under the ambit or will still be under the control of the old laws. Now, another thing is what? implementation challenge. Like we discussed, na, implementation challenge, infrastructure, finance, videography. How is it? What comes under implementation challenges? Okay? It's just a simple way from law schools to Labasna. Everything has to be changed now. Again, I'm repeating. From law schools to Labasna, the whole documentary, the whole syllabus, everything needs to be overhauled. If you'll remember, it's a good thing from the law schools, from the basic law school till Labasna, where you're aiming to go, everything will be overhauled. Now, a few prelims facts related to it you need to remember. Okay? A few prelims facts. Okay? Now, we all know PIB. Subah padna hota, every day you need to read it, or weekly, whatever you like it. PIB. What PIB did? PIB conducted Vartalap. Okay? It is a simple Vartalap is a conversation. So we need to remember in the prelims, if whatever it's a matching question or the word Vartalap is related to what? It is related to Vartalap. It is related to what? All the Bhartiya Nyay Sahita and its changes, and it means conversation, and its aim is what? Awareness about the change which is happening in the criminal codification of laws. Okay? Other is what? Modifications in CCTNS. This was the first point. CCTNS. Full form pata hai? Full form is Crime and Criminal Tracking Network System. Okay? There were modifications. These are all the implementation challenges. It's very like what happened after demonetization. It was our Honorable Prime Minister, he came and he just said that from now onwards demonetization. But we saw another implementation challenge, the magnitude that it happened. Every person, every individual in India, and to some extent a few people abroad also, had so much trouble. So that comes under what? The idea, no matter how strong, it has to be implemented in the same letter and spirit on the ground. So these are the implementation challenges. There are many modifications being done. See, it is a criminal tracking network system, so it needs to be modified keeping the present laws in mind. Okay. Last is what? NIC, National Informatics Center. Third is NIC, National Informatics Center. What it did was, it developed a few apps names. You need to remember this for prelims point of view, and a general answer that E-Sakshay, Nyaya Shruti and E-Saman. E-Sakshay plus Nyaya Shruti. Please don't tell me I need to write down E-Saman. You know the spelling of E-Saman, so just write it down. E-Sakshay, Nyaya Shruti and E-Saman. These are some of the initiatives of National Informatics Commission. Okay? So we discussed everything, the problems that had earlier, colonial problems, then the consequences which it had for the past 70 decades or so, 70 years or so, 7 decades or so, and the present change which we are looking forward to, and everything is good, but it has to be implemented in letter and spirit. Okay, so these were the concluding ideas. Okay? Next, after this, in the next class we will discuss what? The next is police. We have discussed so much. All this framework change is related to what? The police. So we need to discuss the police part. Okay, that's it for today. We'll see you in the next class. Thank you.